Welcome to the Deep Dive, your shortcut to getting really informed. We cut through the noise to give you the essentials. Today we're navigating that really complex world where ideas become protected assets. It's a place where, honestly, the smallest detail can shape an invention's global path.
That's absolutely right. Intellectual property, especially patents, it's incredibly valuable. But taking that protection international, that's where it gets tricky. Understanding the basics isn't just helpful, it's really non-negotiable.
Exactly. And that's why we're continuing our focused journey through the Manual of Patent Examining Procedure, the MPEP. This is part of our ongoing educational series where each deep dive looks closely at one specific section. We're still in Chapter 1800, which is all about the Patent Cooperation Treaty, or PCT. Today, we're zeroing in on MPP Section 1812, Elements of the International Application.
Right. And our mission today really is to give you the essential blueprint for any international patent application. We're going to break down not just what you need according to the PCT, but, crucially, why each part is so vital for protecting your invention globally. Knowing these building blocks, well, it can help you steer clear of common traps.
Okay, let's get into it. Imagine you're building this legal fortress around your invention, one that needs to hold up worldwide. The PCT, specifically Article 3 and its rules, sets out the absolute must-haves, the 5 core pillars for every international application. So what are they?
Think of it like putting together a really critical legal puzzle. The very first piece, maybe the most important for, getting your place in line globally, is the request. This isn't just paperwork, it's your official start. It's you telling the world, hey, I'm seeking protection for this. For U.S. applicants, that usually means Form PCTRO 101. Even a small error here could mess up your filing date worldwide, and that date is everything for priority.
Okay, so the request is like the official timestamp.
Correct.
Crucial. What comes next in explaining the invention itself?
After the request, you need the description. This is where you tell the whole technical story. It has to be detailed enough that someone skilled in that specific field can understand it and, importantly, actually recreate your invention. It's not just what it is, but how it works, the problem it solves, and the best way to make or use it. A weak description can undermine your claims later.
Right, because the claims need that support. So after describing it, you define the legal territory. That's the claims, I assume.
Precisely. The claims are really the heart of it all, legally speaking. These are those concise, numbered statements that define exactly what you're trying to protect. They carve out the invention's novelty and utility. Think of them as the legal fence. Too broad, maybe not novel. Too narrow, someone might easily design around it.
Okay, request to start. Description for the details, claims for the boundaries. What about the abstract? I always see those at the front.
Yes, the abstract is required, but here's a really key point to remember. Its only job is technical information. A quick summary of the tech field and key features. It is not used and cannot be used to figure out how broad your claims are. That's a common misunderstanding, but the MTP is very clear.
That's a big one. So it's like the blurb on a book cover gives you an idea, but you don't argue plot points based on it.
Yeah.
And the last essential piece.
The fifth pillar, if it's needed to really show the invention, is the drawings. For many inventions, mechanical things, complex systems, drawings are essential. They show relationships and parts much better than just words can. They help visualize it.
So request, description, claims, abstract, and maybe drawings. Got the 5 pillars. But just having the parts isn't enough, right? The order matters.
Oh, absolutely. The PCT system is very strict about the sequence. It has to be uniform for all the different patent offices. You must start with the request, then the description, then the claims, then the abstract.
Okay, strict order. Request, description, claims, abstract.
And finally, the drawings, if you have them. Mixing that up can cause delays, maybe even rejections.
And what if it's, say, a biotech invention with DNA sequences? Where does that fit in?
Good question. Sequence listings are pre-specialized. They have their own place right at the very end after everything else. Technically, they're considered part of the description, but they get their own section. It keeps that highly standardized genetic info separate but included.
Wow, okay. Precision seems to be key, not just in what you include, but how you present it. So beyond the content and order, what about other precise stuff like formatting, fees?
You nailed it. Precision is critical everywhere. First, language. The application has to be in an acceptable language. If it's not English, you'll need an accurate English translation and a statement saying it's accurate.
Makes sense. Got to make sure everyone can read it. And the document itself, like how the pages look, page numbers.
Yep. Very specific physical and formatting rules. They're designed so documents can be scanned and reproduced easily worldwide. Like page numbering, all sheets use Arabic numerals, but, and this is interesting, they're a separate series. The request gets its own number series. Then the description, claims, and abstract share another series.
Right.
Any drawings, that's a third series. And if you have that sequence listing we talked about, that gets its own fourth series of page numbers.
Huh. Like different volumes of a book, each with its own pagination, that's detailed.
It ensures clarity. Think about a biotech application with a DNA sequence list. That listing part needs its own separate numbering.
Got it. Are there any weird rules about the drawings themselves that might, trip someone up?
Definitely a few things to watch out for with drawings. Views can't be connected by projection lines, for instance. No center lines either. And you absolutely cannot put things like actual size or scale 12 on them. Those become meaningless when the drawing gets reproduced.
Right, because it could be printed at any size.
Exactly. And if the office tells you to fix your drawings, you have to submit totally new, perfect sheets following very specific rules. Small details, big headaches if you miss them.
Okay, drawings are serious business. Now, for people in biotech, those sequence listings sound complex. What are some key requirements there, especially with recent changes?
Yeah, they are complex. For applications filed on or after July 1st, 2022, you must follow WIPO standard ST.26. It's incredibly strict. It's not just giving the sequence, it's providing it in a specific machine-readable format with specific symbols, length definitions, like there are rules for defining amino acids or nucleotides, which symbols to use B for aspartic acid or asparagine, X for unknown. It's super precise.
Wow. Why so strict?
It ensures these massive biological data sets can be understood and processed the same way by patent offices everywhere. Universal compatibility.
Makes sense. And given how huge these files can be, any practical tips for filing them electronically?
Good point. Electronic filing systems, like the USPTOs, have limits. ASCII text sequence listings are capped at 100 megabytes for e-filing. If yours is bigger, the advice is file the rest of the application electronically first. Get that filing date locked in. Then, on the exact same day, submit the massive sequence listing on read-only optical discs, CD or DVD by mail or hand delivery.
To get the same filing date for everything.
Exactly. That same filing date is crucial for priority.
It really sounds like a minefield of rules. What if someone files an application that seems to cover, like, 2 different inventions? Is there a rule about that?
Yes, absolutely. That's the unity of invention rule. Basically, one application should cover one invention or a group so closely linked they form a single concept. If the International Searching Authority thinks you violated this, they'll tell you and ask for more search fees, one fee for each extra invention they identify. Usually get about a month to pay.
Okay, so you pay more, but it doesn't kill the application.
Right.
Yeah.
Importantly, the application isn't just considered withdrawn or anything just because of lack of unity. You pay the extra fees to get the other parts searched. It keeps the search focused.
That's probably a relief for some applicants.
Okay.
Last practical bit. Money. Fees. Are there any discounts available?
Fees are essential, obviously. Got to pay on time. But yes, good news for smaller players. International applications have been eligible for small entity discounts since early 2014. And here's a neat trick. Just paying the exact small entity fee amount automatically tells the USPTO you're claiming that status.
Oh, that simplifies things.
It does. And there's also micro-entity status for even bigger discounts, but the rules are tighter. You can't, for example, have assigned rights to a company that makes too much money. It's really aimed at independent inventors and very small startups.
That's great. Makes global protection a bit more accessible. Okay, we've covered the elements, the order, formatting, unity, fees. Could you maybe walk us through a quick practical example, say, for a mechanical invention?
Sure. Let's imagine a U.S. inventor files for a new type of gear system for maybe wind turbines. They'd start with a perfectly filled out Form PCTRO 101, that's the request. Then a really thorough written description of the gear system, how it works, its advantages, all the components, detailed enough for another engineer to understand.
Right, the enabling description.
Exactly, followed by carefully drafted claims defining exactly what's new and inventive about their gear system. After that, a concise abstract summarizing the technical field, just for information.
Not for defining the scope?
Definitely not. And finally, a set of clear, labeled engineering drawings showing the device from different angles.
And how do they actually submit all that?
Well, these days, systems like WIPO's ePCT are a huge help. They can digitally create and submit the whole package, just one copy needed directly to the U.S. receiving office. much smoother than paper.
Okay, so the application is in. What happens next? Any big milestones or things to watch out for after filing?
Definitely. The first major public step is international publication. Usually this happens automatically 18 months after your priority date. The whole application becomes public worldwide.
18 months. Can you make it happen sooner?
You can. Applicants can request earlier publication if it fits their strategy, maybe to warn off competitors sooner. PCT Article 21 covers that.
And once it's out there, can you still tweak it, make changes?
Yes, there's a key opportunity for amendments. You generally have the right to amend the claims, the description, even the drawings. This typically happens before the International Preliminary Examining Authority, the IPE, finishes its initial look at patentability. It's a really valuable chance under PCT Article 34 to refine things based on search results or other feedback.
So you can strengthen your case during the international phase. What if you just made a simple typo, an obvious mistake in the original filing?
Good question. There's a process for rectification of obvious mistakes. If it's really clear from the documents that something else was intended, like a clear typo or clerical error, you can usually get it fixed. It prevents minor slip-ups from causing major problems down the road.
That's helpful. Wow, that's a ton of detail, but it really hammers home how incredibly precise you need to be at every single stage. We've covered the core pieces, the strict rules, the formatting demands. It really shows how careful attention impacts an invention's whole global journey.
And that leads to kind of a final thought to ponder, doesn't it? In this super interconnected world, think about how one tiny slip-up, a formatting error, a wrong page number in that initial international application could ripple outwards. How might that affect the patent's strength or enforceability in different countries, maybe years later? What does that tell us about just how critical precision is in these global legal systems?
That's definitely something to think about. That initial filing really does set the foundation for everything that follows globally. We really hope this deep dive into MPP Section 1812 has given you some valuable insights into international patent applications. Remember, this is just one part of our ongoing series on the MPEP, aiming to equip you with knowledge section by section.
And we absolutely want to give a special thank you to Mike Shepard. He's the creative director who put this whole audio series together.
Yes, thank you, Mike. And finally, our usual but very important disclaimer. This summary was generated using AI tools like ChatGPT and NotebookLM. It might have errors or leave things out. It's for general educational and informational purposes only. It is definitely not legal advice and no substitute for proper instruction. For the official word, always consult the actual MPEP, a qualified instructor, or a registered patent practitioner.
Join us next time for another deep dive.
Until then, stay curious.